5 seconds to go. Start. This appeal has a checkered history. The appeal was heard by a bench consisting of two honorable judges, Justice A.K. Ganguly and Justice Swatantra Kumar, and was decided by the judgment dated 18th August 2011 with divergent opinion. In the process, after consideration, Honorable Justice A.K. Ganguly arrived at the conclusion that taking over possession of the land without complying the requirement under section 17(3)(a) of the Land Acquisition Act 1894, for short Act 1894, is clearly illegal and in violation of the statutory provision which automatically violates the constitutional guarantee under Article 300(a) of the Constitution. However, on taking note that the land had been utilized and developed by the beneficiary of the acquisition, had allowed the retention of the land by directing to pass an award by construing the date of filing the writ petition, that is 1st March 2006, as the date of section 4 notification to reckon the market value as against the actual date of notification, hence allowed the appeal in those terms. On the other hand, Honorable Justice Swatantra Kumar, however, disagreed with the said conclusion and for the separate reasons assigned by the learned judge, arrived at the conclusion that Section 11(a) of Act 1894 has no application to acquisition under Section 17 of Act 1894. It was further held that the default in complying with Section 17(3)(a) of Act 1894 does not invalidate or vitiate the entire acquisition proceedings. The learned judge, while deciding so, had however misconstrued that 80% of the estimated value in terms of subsection 3(a) of section 17 had been paid to the land loser, and in that context held that the interest provided in terms of section 34 will be payable. In that view, the learned judge ordered dismissal of the appeal in terms of the directions issued. In that backdrop, in view of the divergence of opinion between the learned judges, they had ordered the matter to be placed before Honorable the Chief Justice of India for reference to a larger bench to resolve the conflict. It is in that circumstance Honorable the Chief Justice has ordered the matter to be placed before a bench consisting of 3 judges. However, no specific question has been formulated and referred for decision by a 3-member bench. Hence, we have heard the matter based on the factual aspects involved in this case de novo, so as to determine the legal aspects which touch upon the same. It would therefore be necessary for us to, at the outset, take note of the factual metrics involved in this case. The new Okhla Industrial Development Authority, Noida, respondent number 2, was to implement a planned industrial layout in Gautam Budh Nagar district, for which purpose the requisite land was to be required. The project was envisaged by the state of UP, respondent number 1, as a part of planned industrial development. Hence, respondent number 1, being the appropriate government, issued the notification dated 17th April 2002 invoking the special power due to urgency. Stop.